today's date is serial number 1 and 2 will fix for 215. So
did you have reference?
Yes. So I was jointly paying with the consent of the other side. I was paying if you can please put Tuesday if it's possible.
Tuesday.
Or any day subject to available. It's a part that matter that same.
Yes. Tuesday को push रखते हैं.
आगे में तो one side.
Tuesday at 2:15.
This serial number 48 है.
Yes, that's right. Serial number 1 and 2 में लिखिए. Who is for the petitioner? You are for the respondent, I suppose. Who is for the petitioner?
Petitioner may have joined online.
He's not there.
He joined online. I mentioned with consent. He's also there. I thought he's joined.
Maybe he must have gone to
He
the
just joined.
He's not there.
But I'll inform you. We are mentioning with consent.
I take it that there is consent. Mr. Pandey, are you agreeable for Tuesday?
Yes, my lord. At 2:15, my lord.
Yes, with the consent of the learned counsel for the parties.
I am highly obliged.
Pose this case on Tuesday at 2:15.
Highly obliged, your lordship.
Counsel for the petitioner has joined online.
एक सीरियल नंबर 48 है डेली रिस्टोरेशन मैटर है पुलिस तंत्र करे जैसे ही रिस्टोर होगा विदिन ए वीक हम सरेंडर करेंगे रिलीजन का कन्विक्शन मैटर 498 का इन लॉज है मदर इन लॉ एंड फादर
आपका ऑन सरेंडर सर्टिफिकेट के एब्सेंस में ना हुआ है
नहीं और लॉर्डशिप का आदेश
डिसमिस फॉर डिफॉल्ट हुआ होगा
हां
for want of surrender certificate you file surrender certificate then only it will be dismissed.
Serial number 57 is CMP for modification of the earlier order. There was a direction issued by the lordship for the removal of defects till 20th of March, but we could not remove the defects because of only for modification of the said order, so that we can because there was a direction of the court.
So it has been dismissed for default.
No, no, since there is a specific order that the defects are to be removed by 20th of March, but you could not remove them. So now office is not allowed to remove the defects. But there was a stipulated time.
Come at 12.
12.
On behalf of Mr. A.K. Chaturvedi, sir.
Yesterday so many cases are every day his cases are adjourned and every day at his request a new date is given. Why do you take a date when you cannot appear?
I'll say
ठीक है रोज नया एडवोकेट आकर उनका मेंशनिंग करता है हाँ यही है हम बता रहे हैं रोज ही यही कहानी है but आज 3 दिन 4 दिन every day what is this
gasping his breath so far as the election is concerned 5 votes 6 votes here and there so today is the final date for
you see आप छुट्टी के बाद आप करिए वेकेशन
नहीं मंडे
ऐसा थोड़ी होता है आप बताइए आपके रिक्वेस्ट से भी पुट अ डेट what do you mean you will be blamed
he front of the bar when she came running and he said please do this for me said well I'll do that for you and 5 votes he just running here and there he's once he's declared elected then again he's said that he's not so this thing is happening today is the final date for it the bar council elections and thereafter he will not ask for it Monday whereas Monday he's saying Monday
मतलब आप जरा सोचिए he does not have the no you आप कुछ नहीं जानते he does not even have the basic courtesy to inform the court master yesterday that I will not do it कुछ भी नहीं
अच्छा उसको नहीं
रोज का यही कहानी है for last 15 days उनका केस पता नहीं क्या ग्राउंड पे इलेक्शन ग्राउंड पे नहीं अटेंड हो रहा था it was some other grounds not well somebody in the hospital यही सब चल रहा था
but I know
election ground पे पहली बार
I have a pity for that man he's on the I mean just hanging
कौन सा केस आपको
दो ही है सर उनका 23 और 62 जो हमको दिए हैं अपना लिस्ट पढ़ा के दे दिए बस मंडे के लिए उन्होंने बस ये क्या किया आज भर के लिए किया 23 and 62 I hope it is A.K. Chaturvedi sir's case अब सीनियर
At the request of learned counsel for the petitioner, दोनों के उसमें लिख दीजिएगा. By way of last indulgence, the matter is adjourned for Monday. पास ओवर भी हम नहीं देंगे,
नहीं।
DFT कर देंगे. अगर वो नहीं आए
तो बिल्कुल हम बोल
हम DFT कर देंगे. You
हम
better
खड़े
take
होके
it.
बोलेंगे DFT कर दीजिए, मेरे साथ भी बेईमानी की है, बोल के ऐसा हम बोलेंगे.
ये नहीं कि आप पास ओवर नॉट टुडे ऐसा कुछ कहानी नहीं. जब
नहीं,
केस
हम-
फॉलो हुआ ही शुड बी हियर. 4 बार केस आज नहीं, मंडे.
मंडे को हम रहेंगे, अपना केस छोड़ के रहेंगे.
मतलब item number 31 from the BD particular. Contempt matter. मतलब there is an order for personal action. That may be taken up any time before writing.
31 क्या चीज के लिए हम बुलाए?
उस सुप्रीम कोर्ट से सेल्फ डिसमिस हो गया था, उसके बाद भी कंप्लेंट नहीं हुआ था.
क्या हुआ? अभी तक नहीं हुआ कंप्लाइंस.
अभी तो कोई एफिडेविट तो फाइल नहीं हुआ, लेकिन वो लोग आए हुए हैं तो.
क्या करने के लिए आए? पर्सनल अपीयरेंस इसलिए थोड़ी करते हैं कि हम उनको शक्ल देखना चाहते
अब they should give the
हैं,
undertaking.
कंप्लाइंस देखना चाहते हैं.
मतलब they should give the undertaking मतलब their payment.
एफिडेविट बोलिए साथ में लेके आइए,
जी.
बना के लेके आइए 1 o'clock.
May I mention for the fresh filing list for the state of Defect number 73/2026.
फ्रेश फाइलिंग.
From supplementary list for judgment item 2 AB 7285 of 2025 along item 3.
both are dismissed.
Also, the matter is registered on 30th of April. That will also be granted file counter affidavit in advance also, along with the case diary. Today we are filing the counter affidavit, but this is the case diary, not something.
This is the only case that.
Yes, this is a relevant case diary. We'll consent to the case laws and we'll file the entire case diary also.
I think it is that case where it was submitted that the petitioner was not a director at the
Yes,
time.
sir. The link.
Was he the director?
Lordship, they have filed the documents not showing the DIR1 in form 32.
They have filed their supplementary.
They have filed this.
Item from daily list item 42 BA 12172 of 2025.
You filed your counter affidavit.
Yes.
Where is the petitioner? Petitioner absent by way of last indulgence post this case on Monday.
Item 63 BA 1060 of
Mr. Roy, your case has been called out. Are you aware? आप इन्हीं का तो केस है.
Yes.
आपको देख लिए नहीं तो मंडे. हाँ बताइए.
इसी के लिए I'm extremely sorry. That's the case of laws under section 96 of BNS and 3 and surplus 5 of the BNS, that is procuration of minor child. That's the case. That's in which जो पहले बेल के पहले एक क्लाइंट वाली बहस कर देते हैं कि इसमें सिमिलरली सिचुएटेड 2 आदमी का बेल हुआ है और जो मेन एक्यूज है उनका रिजेक्ट हुआ. उसके बाद हजूर हम आ रहे हैं एप्लीकेशन. As per the allegation, it is alleged by the informant who happens to be the mother of the victim that on the relevant day, she along with her daughter, the victim, had gone to her parental house and where she dropped her daughter and returned back to her matrimonial house. But in the evening at around 4 p.m., the daughter, the victim, returned back to her home. But thereafter, since 7 p.m., she was found to be missing. They started to search, could not get any clue. In the midnight murders, she got information from Purnia authority murders that your daughter has been apprehended along with some other persons and she is in the possession of the authority of the Purnia. Upon that murders, the girl was recovered and my case is that, my lords, my case stands on the similar footing to the co-accused, my lords, two persons. Petitioner is not named in the first information report, and even, my lords, he has not whispered a single word that has come in the order of the co-accused, my lord, passed by the coordinate bench. I am the driver of the vehicle. That's all, my lord. The girl has stated in her petition कि ये हमको बोल करके ले जा रहा था कि हैदराबाद ले जाएगा और फिर गाड़ी में बैठाया तो उसमें और हम जो स्टेटमेंट पढ़ देते हैं, एकदम छोटा सा है।
183 का BNSS का स्टेटमेंट कहाँ है?
हमारे पास BNS आई है और
रिकॉर्ड पे भी नहीं है 183 का स्टेटमेंट, केस डायरी में भी नहीं है, कहीं नहीं है।
डायरी में BNS का स्टेटमेंट
183 का स्टेटमेंट है,
180 का है।
180 से क्या 183 का स्टेटमेंट।
तो इसी बेसिस पे और लोगों का बेल हुआ है कि she has not whispered a single word.
Office is directed to call for the statement of the victim recorded under section 183 BNSS from the concerned court along with the medical examination report of the petitioner of the victim. Post of the case. 13 183 का स्टेटमेंट ही नहीं है इसमें, केस डायरी में नहीं है। On 13th लड़की के साथ 13 साल की लड़की के साथ पूर्णिया में पकड़ाए हैं, तो थोड़ा वेट करिए।
बाकी लोग का बिल हो गया।
कोई बात नहीं।
Item
183 का स्टेटमेंट देख के भेज हुआ ना, तो स्टेटमेंट देख के ही भेजें।
Item 63 BA10C0/2026.
The initial FIR was lodged by the lady owners, the deceased, under section 109, corresponding to section 307. A charge sheet has been filed for abatement to suicide. Can I just read the FIR? Must things will be clear that it was a case of accident. The petitioner before your lordship was in a relationship with the victim lady. Page would be minus 20 for the man of the lady. Therefore, I'm reading deceased. मेरा नाम so and so, उम्र so and so, पिता so and so.
She is the victim.
She is the victim. She died subsequently. अब सोन रिसर्च रिपोर्ट अनुवाद वर्तमान पता so and so आजाद नगर जिला पुलिस में रहने वाले। मेरी पहचान पिटिशन नंबर so and so शादी कॉल से हुई। शादी.com से हुई। कृष्णा सिंह ने मुझे शादी का वादा किया और परिवार वालों से लड़ झगड़ कर मुझे यहाँ टाटा जमशेदपुर में लाया और चाणक्यपुरी में डेरा लेकर पति पत्नी की तरह रखा। लेकिन धीरे धीरे कृष्णा का व्यवहार बदलने लगा और छोटे बात पे झगड़ा करने लगा, बार बार छोड़ने की धमकी देने लगा। एक दिन कृष्णा की फैमिली से मेरा झगड़ा हो रहा था। इसी में मुझे पता चला कि कृष्णा पहले से अनीता सोनसो लड़की के नाम से शादी कर चुका है, वो भी ये टाटा में ही कहीं रहती है। कृष्णा ने मुझे बताया कि सोनसो अभी तक कोई संपर्क नहीं हुआ है। मैंने उसकी बात मान ली और ठीक से रहने के लिए, लेकिन पर त्योहार में कृष्णा जब घर नहीं आता, बाहर रहता, तो दोनों को इस बात को काफी झगड़ा होता। कृष्णा मुझे जूते और पेड़ से बुरी तरह मारता था। मैं अपनी बात परिवार को भी नहीं बता पाती थी। कृष्णा मुझे घर से निकालकर नदी में फेंकने की धमकी देता था। एक दिन अनीता मेरे डेरा पर आई, मुझे झगड़ा किया और कृष्णा को नहीं छोड़ने पर मिट्टी का तेल डालकर जलाने की धमकी दी। मैंने ये बात कृष्णा को बताई, लेकिन अपनी बात का विश्वास नहीं किया, उल्टा झगड़ा किया और घर से निकल गया। मेरा नंबर ब्लॉक कर दिया। उस दिन बाद फिर कृष्णा आया और मेरे साथ मारपीट किया और बोला कि तुम मर जाओ तो क्या होगा, जेल जाएंगे। जेल पहले भी गए थे, फर्क नहीं पड़ेगा, लेकिन तुमको जिंदा नहीं छोड़ेंगे। कृष्णा का जब मन होता आता आधा राशन ला देता, मारता पीटता, नंबर को ब्लॉक कर देता। कल भी अनीता शाम को मेरे डेरे में आई और बोला कृष्णा अब मेरे साथ रहता है, तुम उसे छोड़ दो। मैंने बोला कृष्णा से 5 लाख रुपया देकर जेल से छुड़वाई। मेरा सारा गहना जेवर ले लिया है, सब वापस
करे तुम भी शांति से रहो और मुझे भी शांति से रहने। लेकिन अनीता मेरे साथ मारपीट करने लगी और अपने साथ लाए तेल मेरे ऊपर डाल दी और गंदी गंदी गाली देकर बोल दी आज जलाकर मार देंगे। मैंने किसी तरह खुद को बचाकर कमरे में बंद किया। जब अनीता चली गई नाउ काइंडली तब मैंने पैर पोंछना जो कि पहले से धक्का मुक्की में तेल से गीला हो गया था, मैं माचिस मार कर चेक किया कि झूठ बोली अनीता की सच। लेकिन जैसे ही मैंने पैर पोंछने की माचिस जलाकर चेक किया तो भीगी हुई थी तेल से और आग पकड़ लिया और मैं बुरी तरह से जल गई। कृष्णा सिंह ने झूठ बोलकर मुझसे शादी किया, झूठा नाटक किया, बिना शादी पति पत्नी डरा धमका कर रखा और अनीता के साथ मिलकर जान मार की नीयत से मेरे ऊपर मिट्टी का तेल डलवा दिया जिससे चेक करने की जरूरत रही। So this was a case of accident. No one put her on fire. She wanted to check whether the lady who had come.
She could not be put on fire because she locked herself in the room
No,
and saved herself from Anita.
But she did not. There was no attempt also by this lady, other lady. Anyway, let me assume that that lady, the other, my wife Anita wanted. I am not present at the place of offense. It appears that there was an extramarital affair. She claims to have spent some money on me, and therefore she also wanted to make peace on that money thing. And now, as I am in custody minutes from 13th of September 2025. The state judgment's cognizance has been taken. Charges are also being taken.
And what about Miss Anita?
Anita was not sent up. Anita was not sent up.
She's not a court case.
No. She was initially, but after investigation, because the abatement to suicide, she was not found. Well, abated. But as a matter of fact, I have also not abated.
Charge has been framed under section 108.
Yes.
Where is the opposite party?
I have been sorry.
Opposite party is absent.
Yes. Only Shubham Singh, I have a certified copy of the heading of charge, which is Lordship so and the charge.
About the learned counsel for the petitioner. Nobody appears on behalf of the opposite party. The learned counsel for the petitioner submits that there is an allegation that the petitioner and the victim got friendly through shadi.com and they started living together. And subsequently, the victim came to know that the petitioner was already married with the lady. As per the allegation, the lady had come to the house and poured kerosene, but somehow the victims locked herself in a room. And in the FIR itself, she has stated that in order to test as to whether the liquid was kerosene oil, she tested it by lighting the matchstick, and in that course, she also caught fire. The learned counsel submits that admittedly the petitioner was not at home, even as per the FIR instituted by the victim. However, the victim subsequently expired. The case has been lodged. Ultimately, the charge has been framed under section 108 of DLS. He submits that the petitioner is in custody since 13/9/2025 and charge has already been framed. A counter affidavit has been filed by the state opposing the prayer for bail, by wherein it has been stated that the petitioner used to repeatedly quarrel with the victim and the victim suffered 95% injury. After hearing the learned counsel for the petitioner and upon going through the FIR, it was lodged by the victim herself, who died subsequently. It seems that the victim had lit the matchstick and ultimately she expired. In view of the objective facts and circumstances, the petitioner is directed to be indicted.
Item 64, BA 2147 of 2026.
Initially, the case was brought under section 87 of BDNS. The FIR is at page 30.
The learned counsel for the state is directed to file a counter affidavit. Let the case diary be called for from the concerned court along with the statement recorded under section. Statement of the victim recorded under section 183 of BNS. Yes. That notice, the state is also directed to serve notice upon the victim. The counter affidavit along with service of notice to the victim should be filed by 13th May, post on 15th of May. Since the counsel for the state is absent, कौन है state का counsel? Office is directed to forward a soft copy of this order to the council to ensure compliance. Antecedent report this afternoon. 15.
Supplementary is for findings to item 1, second appeal 556 of 2004.
But this matter I have addressed in the last question.
Yes.
Still, Your Worship, two more things I require to address. So the question of law, Your Worship, is only with respect to exhibit C. That I have already argued. And I have shown from our the judgment that it was not considered at all by the applicant.
Yes.
And so far as the trial court, Your Worship, is concerned, trial court was swayed by findings of the revenues.
Of the?
Revenue matter.
That's
Your proceedings under section 20 and 42. Where is those courts have commented that this appears to be a policy. And this was the issue I have already addressed. Two things I would like to point out. First thing, that the section 20 and 42 proceedings, those were instituted by one Talim. Your Worship, who is my full brother. He is not a Jama Bandi. That point has to be taken into mind. This is not this proceeding was not on behalf of one of the recorded Talims or their heirs, who has granted Ulfa Nama. So, what would be the effect, or what would be the position in law with respect to a finding to which MD Talim himself was not entitled to it. So, I want to say that this aspect of the matter has not been viewed from that angle. And strangely, in the suit, that Talim who had filed those proceedings against me for my eviction, I was claiming by virtue of court.
From where do we get who was Talim and all these details that he was your full brother?
From the order sheet, Your Worship, you may kindly see. Exhibits.
No, exhibit that is
Malad has taken into consideration these aspects on the last.
You read the last order.
Yes.
Last order नहीं है आपके पास? नहीं है?
I have already got. My lord has passed already detailed.
प्रिंट चाहिए? You need a print? एक प्रिंट कीजिए 16/4/26 के ऑर्डर 16/4/26 के ऑर्डर करेंगे I'll give you a print just a moment.
These are not disputed. My lord may just have a look.
Have you gone through this order?
Yes, I have gone.
Everything is correctly recorded? Everything is correctly recorded?
Some points are required to be recorded. On the point of
On the point of?
law.
No, whatever, you see, you have to confine your arguments on the point of law already framed.
Yes, that I correct. But your lordship may kindly appreciate. Though I am a counsel for this, and my lord, I am little bound to argue, but what is my lord, the case of the lady. But my lord, being the officer of the court, I have to, my lord, it is a bounden duty on my part to at least, my lord, make my lord, my submissions that what is the correct position in the law.
You see, if once a substantial question of law is framed, that is it that we are going to hear. We are not going to reopen anything.
No, I am not on that. I will be arguing on those points. That is the reason why I am arguing.
Those points means which points?
Regarding endorsements.
No, I will not permit that.
No, but may I say,
No, I will not permit that. There is no question of any argument on it.
that is required to be.
We have to only see the consequence with regard to Exhibit 7 and nothing.
But those are the points. Those are the legal
No,
issues.
it can't be. It can't be like
Those
this.
are the
You
legal
just
issues.
you just can't go on like this. There is no petition for any additional substantial question. There is nothing. And in the midst of the proceedings, you have completed your argument rather. And now you say that you will open the Pandora box.
No,
You
I
will
am
not
not
permit.
opening.
Then what is it? How will you, under what provision, under which question of law can you now go on arguing on adverse
Exhibit
position?
7 itself. Exhibit 7, Your Lordship, by virtue of Exhibit 7. My lord, the court has concluded that, my lord, it is the defendant, my lord, who was the defendant in that proceeding, my lord, Exhibit 7. Defendant has acquired right by virtue of adverse position. I am saying that whether that was correct or not, that is to be seen by the court also. I don't want, my lord, that my lord must, my lord, decide this issue as per the law.
Yes, we will decide it
Yes.
as per law. Please
Two
don't expand your.
judgments, my lord has asked me to go through.
Yes.
I have gone through judgment. I have brought those copies.
Sure. You read this 16/4/26
Yes.
once.
But learned counsel for the party. Learned counsel for the opponent, title suit number 125 of 1968 was filed by Seth Cherry, D.T. Gopina, D.T. against Jharkhand in adverse position of defendant in the suit was declared by the duty collector Goda by judgment dated 4/11/1968 in itself. The suit was dismissed by observing that Sheikh Jar Ali had perfected his title by adverse. Earlier case number 26 of 3869 was filed by Sheikh Ali of village Kakamaria against Sheikh Cherry, B.B. Gopina, D.B. Zaitun under section 20 of Santhal Paragana regulation, which was dismissed by order dated 22/5. The appeal against the said order was numbered as revenue miscellaneous appeal, which was filed by Sheikh Ali against the Sheikh Jar Ali, Sheikh Cherry, Usman B.B. Gopina, and B.B. Zaitun was allowed by the mandated discharge. And consequently, Sheikh Jar Ali was directed to be evicted from the plots mentioned in Quran 15/5/1940. and the plots were directed to be restored back to respondent second party, namely Cherry, Mosman, Bibi, Sakina, and Bibi Zetu, and it was observed that the land would become available for settlement with local deserving tenants. The finding of the learned authority are in para 5 and 6. Against a aforesaid order, 3/4/1971 passed in revision miscellaneous appeal number so and so a revision was preferred, which was numbered as SP revision miscellaneous case number, which was dismissed by the order dated 25/1975. It is further submitted that in the present case, Sheikh Jar Ali is the plaintiff, and initially when the suit was filed, order of revision passed by additional deputy commissioner in review miscellaneous appeal number 171 of 71/71 dated such and such and order dated such and such passed by the commission. However, in the speed interim case number 7, the challenge by virtue of amendment in the claim, the challenge to the orders was deleted and the suit was confined to declaration of title and confirmation of possession. Now the counsel for the appellant has relied upon the judgment passed by the bench of the Honorable Patna, 15 case of the past in context of the court and submit that there would apply in present case. We submit that there cannot be any bar seeking declaration of title by filing a suit, even if the revenue authority has passed order under section 20 of the Contempt Act, directing for eviction of the plaintiff. We submit that under the aforesaid circumstances, judgment passed in title suit number 125 of 1968 declaring the advance to apply, who is the plaintiff in the present case and the defendant in the title suit number 125 of 1968 is defined. And therefore, the judgment passed in title suit number 125 of 1968 has not properly considered by the law. Submit that if the exhibit 7 is taken into consideration, there can be no dispute with regard to position and the title was only declared to be required for reverse. And it is the specific case of the plaintiff in this case that they are in the cultivating position of the property and also are constructed a residential house over the property. Having given aforesaid background, the learned counsel for the appellant has submitted that the trial court recorded that the judgment passed in title suit number 7 challenge before the DT Commission in miscellaneous case number 172 of 71, where it was recorded that the judgment in title suit was false. Then the counsel has submitted that the judgment passed in title suit number 125 of 68 was never shown. Rather, miscellaneous case was arising out of the proceeding initiated under section 20 of the Contempt Act. Then the counsel has submitted that the learned court has committed error of law. Then the counsel for the appellant has submitted that the first appellate court has recorded the finding in part 8 of the appeal judgment that there is no constitution of the exhibit 7. The first appellate court has gone into legality, validity of Urfanama and claimed that the learned court trial court has rightly distributed the case. Learned counsel for the appellant comment that if the exhibit 7 was considered, there was no scope to disbelieve Urfanama, in as much as Urfanama was duly accepted as valid by the learned court which further became the basis of declaring a first position, who was the defendant in title suit number 125 of 68. The judgment in title suit as it is given. The counsel for the appellant has submitted the suit contained in exhibit 7 is referable to suit under section 5 of the Contempt Regulation, and has submitted that there was a complete bar in filing the suit in civil courts established under the law. The suit was required to be filed before the prescribed authority in terms of section 2. Here, however, it is during the settlement process.
That's right.
Here, that is missing.
But there is,
to that extent, the
we do not know whether when the settlement process was going on. That is why that sentence is
Yes.
missing.
learned counsel for the appellant has also.
Yeah, I've got it. I've recollected it completely.
Yes.
Now you tell me two things.
Yes.
Where is the judgment of Paritos Mehti?
That is true.
No, Paritos Mehti.
I will give you.
You have not given it. You never cited. We just referred it. You never gave it on the last date. And there are two more judgments. One is Dev Narayan
Those judgments.
and the other is Bhorilaljan.
Yes.
And Paritosh Mehta.
Paritosh Mehta.
And kindly place these judgments.
Another is Bhorilaljan.
This is Dev Narayan Singh. You have given two copies of Dev Narayan Singh. One should be sufficient. Yes. एक भौरीलाल जैन और पारितोष मेहता. And पारितोष नहीं, वो दिए नहीं. उनको बोलिए ना गोदाई जी को. उनके पास उनको पता है पारितोष मेहता का चीज. 1987.
Though it is on a different context. It is on the
So should I record that you are not relying on that?
Definitely it is on a different context. I cannot argue beyond that part.
The learned counsel for the appellant has submitted that, though on the last occasion, when the matter was heard at length, a reference was made to the judgment passed in the case of Paritosh Mehta, but the same may not be relevant in the present case, as the same was passed in a different context under the provisions of Chotanagpur Tenancy Act, and the present case relates to Santhal Patna Tenancy. Paritosh Mehta नहीं चाहिए. ये बताइए इन दोनों का रेलेवेंस बताइए.
ये दोनों जजमेंट में ये डिसाइड पहला वाला जजमेंट जो देखा जाए
भौरीलाल. यस.
इसमें this proceeding was arising out of section 20 और इससे पहले हम थोड़ा लॉकलेस था.
Yes.
मतलब इसमें संथाल परगना सेटलमेंट रेगुलेशन 1872
Yes. Yes.
इसका सेक्शन 27
27.
ये
Repealed by section 3.
it has been repealed by the supplementary. So earlier, even if there was invalid transfer, the right could accrue by virtue of adverse possession. That was the legal settled legal question.
Is there any judgment on this?
Yes, on this Bhaurilal Jain, this issue was examined with context to section 20. And my lord, in this particular case, the relevant para we are just showing. It's a very detailed judgment, and several things have been recorded. Section 29, 27 has been taken into consideration. Relevant provisions of Santhal Paragana settlement regulation have been taken into consideration. And my lord,
But it says that it has to be within 12 years from
prior to 49.
prior to 49. But if the transfer is after,
1949.
1949 minus 12,
Then my lord, the right would stop. That what is the ratio.
so if it is prior to 1937, then only adverse possession. If it is after 1937,
The kindly see this judgment part.
Para
But
50.
it was just, it is 56.
Yes.
From the aforesaid discussions, did my lord find?
Yes.
I will write the following conclusions. That there is no instance of transferability of realty holdings to the Sultan. That section 20 of the Act is not ultra virus on the ground of being violative of fundamental rights permitting under the Constitution. That section 42 of the Act is the legislation with respect to entry number 21 of this statement of 7th schedule to Constitution and is not violative of being repugnant to the provisions of the Limitation Act, federal legislation dealing with the recognition of right by adverse. But it was argued in this case that the Limitation Act does not apply, but after examining all provisions, etc., what has come to a conclusion that it is as because in the list itself that Limitation Act is there, there are other lists, other acts also, civil procedure code is also there. So, my lord, the act will apply. There is no quarrel on that point. But how and when applied, then, my lord, the full bench has further clarified. Limitation Act was applied to the district of Sardar Karatna Regulation 1872 and adverse position could be acquired under an invalid term in contravention of section 27 of the regulation. Like what I was just saying. Those who did not acquire title by adverse position under regulation 3 of 1872 could be evicted under the old section 25 or section 42 of the Act, even after the repeal of section 1727 of the Constitution, as the Act was supplemental to the regulation. That's what the full bench has got.
So those who acquired title by adverse possession under Regulation 3 of 1872 could not be evicted. So the condition precedent is that you should acquire adverse possession under the Act of 1872, isn't it? Did you acquire?
Section 20 of the Act was prospective, and
That's
there
right.
could not be acquisition of title by adverse possession.
Thereafter. After coming into force of 1949
They would stop.
that would stop and adverse possession will not be acquired. But the point is that if you have perfected the title prior to coming into force of 1949 Act,
Yes.
then you can say that you have acquired adverse possession.
Yes. That what is the ratio laid down by this? My lord, may kindly say
What
this
is the
one.
date of Kurfanama in your case?
That is the reason I wanted to argue on Kurfanama. That is exhibit 2. Though my lord, the Kurfanama has been my lord, recorded on 15th of May 1948. But my lord, the contents of the Kurfanama show that the my lord, the Jharkhand was my lord, in position prior to my lord, 12 years prior to my lord, 1940.
Is dated? Date of Kurfanama?
Date of Kurfanama is 15th of May 1940. It was issued that date is there. That date is there.
But it shows possession from?
I am in possession.
As per Kurfanama, what is the date of possession?
It is written in the Kurfanama. I may be allowed to refer that
You tell us. You just give me the date.
Right? Those 12 years are written in the Kurfanama. Prior to discussion, well, he was in possession. So if that aspect will logically count, then it can be deducted 48 from 12 can be deducted 36, 37. 34, 35 years.
More than 12 years. It was more than 12 years.
Yes.
Diet Exhibit 7. Exhibit 7. एक सेकंड आपको अभी सुने कहाँ है? अभी तक तो आप टाइम ही मांग रहे थे, आपको सुनेंगे।
दूसरा वाला भी जजमेंट की एक बार
Just I will just see that.
Exhibit मतलब may I read the exhibit now? May I read? करीब 12 साल पहले से ही लेकर करीब से गैलरी में हमारे पूर्वजों को जमीन का फसल बांट कर नहीं दिया, न ही जमीन का खजाना ही दिया, नतीजा यह हुआ कि छेदी की नौबत आ गई। यार लेकर करीब यार अली हम लोगों के संबंधी हैं, उन्होंने हम लोगों के पहले बुरे दिनों में काफी मदद किया था, बेकारी लोगों को सुल्फा में पाने के लिए बहुत मेहनत हुआ इंतजार किया। हम लोगों का रेड हुआ कि बुरे हालत में बेकारी ने बहुत मदद किया है, पहले से ही जो आबाद कर रहा है, इसलिए हम लोगों को फुटपाथ में ली।
You see Exhibit 7.
Exhibit 7.
Yes.
But the contents of Ufa have not been properly construed. That's what I was saying. That what was I was saying. And I am on a different pretext also. Your Ashika kindly also.
Your case, the case of the defendant was that the land was given by the plaintiff to the defendant about 16 years ago. That was your specific case.
My case is that.
In Exhibit 7.
But the Kulfa has taken into account.
That
Kulfa
has,
is there.
that's right. But that was your specific case. That it was only 16 years ago.
Page 2, Your Ashika.
Yes, I am there at page 2.
The case of the defendant is that the suits were given by plaintiff to the defendant about 16 years. 16 years of ago, before Kulfa.
कहाँ लिखा है?
ये
वो हम कैसे रीड करेंगे?
तो-
आपकी तरफ से 2-4 शब्द ऐड हो जाने से थोड़ी ऐड हो जाएगा।
Exhibit 2 तो देखेंगे ना। Exhibit 2 में
We will not see
अच्छा
that.
नहीं इसमें लिखा हुआ है, इसको देखें।
Exhibit 2 को हम लोग नहीं देख सकते हैं, कोई रजिस्टर्ड डॉक्यूमेंट नहीं है, कुछ नहीं है, उसमें क्या ही करेंगे?
इसमें एक उसी का एक लाइन और लिखा है। He has acquired the land through Kulfa, he pays rent.
That's right.
तो अच्छा Kulfa has was exhibited in this case.
So must have been exhibited. आपका अपना ही केस था।
नहीं इसमें लिखा है, जो देखा ना।
देख ही रहे।
The fact that admitted by the plaintiff have admitted.
The two witnesses, one of the plaintiff and other of the defendant, have been examined in the suit, besides plaintiff and the defendant. From their evidence, it is clear that the suit land are in possession of the defendant since 18 years. इसको कैसे आंख बंद कर ले बताइए?
Exhibit A and rent receipts were brought on.
कोई मतलब नहीं है ना। अब हम लोग उसके अपील में नहीं बैठे हैं ना।
नहीं बैठे हैं।
इतना दूर नहीं जा सकते।
ये बात हमारा।
आपको मालूम है कि इतना दूर सेकेंड अपील में नहीं जा पाएंगे।
नहीं लेकिन ये तो इसका
खुफानामा में आपका पोजीशन कब से लिखा है, नहीं लिखा है, that cannot be taken into consideration.
If a document by virtue of which the plaintiff is claiming a right.
आपके डॉक्यूमेंट का कोई रजिस्टर्ड डॉक्यूमेंट है आपका कि whatever is recorded therein is the gospel truth? Is it a registered
The
document?
person, Exhibit 7 at least suggests the person who granted the hukumnama, kulfanama, they are supporting us. It is not, they are not saying that it is the first document. They are not saying.
They may be supporting you. That is not the
So
fact.
far as the contents.
Your adverse possession has been declared by way of Exhibit 7. Your title has not been declared otherwise. What has been declared is your adverse possession.
I agree.
So you cannot say that they are admitting your title by way of Kurfanama.
No, they
That
are
is not the
admitting,
case.
they are admitting kurfa. That's what I am saying.
You see, if they were admitting Kurfa, then your title would have been declared.
Title
Isn't
by
it?
adverse possession.
No. Title by adverse possession and title otherwise are two different.
I was not a plaintiff before this court.
Maybe you but you
They
claimed
were-
adverse possession.
They were the plaintiff. They
Yes.
wanted to declare their declaration of title.
That's
And
right.
recovery of possession.
That's right.
But the court said, no, you cannot.
Their title was not declared, rather your adverse possession was declared.
My possession was declared.
Their title was not declared on the ground that your adverse possession was declared,
That is-
not on the basis that you have a khurfa and therefore you acquired the title in
Basis for
1937.
execution was Kurfa itself. My lord, may continue.
तो ठीक है,
Basis
सुनिए।
for
अब आगे बताइए क्या
basis
है?
for acquisition was Kurfa.
That's right,
Now
yes,
the question,
yes.
Your Lordship, I am on a further one step further. Your Lordship. This particular judgment which is in my favor, and that has not been considered by the appellate court. My lord,
That's right.
what is the sanctity of this judgment? And what is the sanctity of this order? My lord, this is required to be considered by this court.
We will consider.
Yes, that is what.
That is why Exhibit 7.
That is why exhibit.
That is why the substantial question
And the
of law.
moment my lord will look into exhibit 7, then
The whole issue is that whether on the face of Exhibit 7,
my,
even if there is an order of eviction passed by the authorities, what will be the impact?
my lord, I would further say that the order of eviction which has been passed against him, it is not at the instance of my lord the recorded tenants. Your Lordship may kindly consider this aspect also. My lord may allow us, my lord, to my lord, refer those exhibits. May kindly see the my lord the exhibits. On the last occasion, my lord, I had got very little time to argue because day before yesterday, my lord was kind enough to provide those documents to me. So, my lord, may kindly see those documents once.
एक सेकंड लिखिएगा. The learned counsel for the appellant has submitted that as per the Kurfanama dated 15/5/1948 within bracket Exhibit 2, Sheikh Zar Ali was in possession of the property much prior to 12 years from the date of Kurfanama. He has further submitted that under such circumstances, Sheikh Zar Ali had perfected his title prior to coming into force of the supplementary provisions of the Santhal Pargana supplementary within bracket supplementary provisions bracket close Act of 1949. He has then referred to the judgment passed by Patna High Court, full bench judgment passed by Patna High Court reported in 1972 SCC online Patna 116, Bhauri Lal Jain versus Subdivision Officer of Jamtara, and has referred to paragraph 56 thereof, and submits that it has been recorded therein that the Limitation Act was applicable under the provision of Santhal Pargana Settlement Regulation 1872, and ultimately it has been held that if a person perfects his title by way of adverse possession prior to coming into force of the supplementary provisions of 1949, then under such circumstances, his adverse possession would be acknowledged. He submits that supplementary provision of 1949 came into effect from from 1st of April 1949, and if a person remained in possession and other ingredients of adverse possession are satisfied for a period prior to 12 years prior to 1st of April 1949, his adverse possession could be declared. The learned counsel submits that since the Kurfa was dated 15/5/1948, which reflected that Zar Ali was in possession 12 years more than 12 years prior to 15/5/1948. Therefore, there can be no dispute that Zar Ali had perfected his title by way of adverse possession. He has then referred to Exhibit 7 and has submitted that Khurfanama was duly exhibited and the same was acknowledged, and ultimately it was recorded that Zar Ali was in possession of the suit property for more than 12 years and has acquired title by adverse possession. दूसरा judgment कौन सा है?
That is Narayan Singh.
He has then referred to the judgment passed by Honorable Patna High Court, full bench, reported in 1984 SCC Online Patna 219, Dev Narayan Singh versus Commissioner of Bhagalpur Division and others, and has referred to paragraph.
Yes, my lord, may kindly see what was the point of law which was before the full bench. May kindly see the
And has referred to the point of law.
First paragraph. Whether the prescriptive period of 12 years for perfecting the title by adverse possession would stop running from the day of November 1949, being the day of the enforcement of Santal Paragna Tenancy Act, is a significant solitary question arising from a deep-seated conflict of precedents within this court, which has necessitated the reference to the court.
The point for consideration before the Honorable full bench was whether the prescriptive period of 12 years for perfecting the title by adverse possession, within bracket, the original transfer being in contravention of section 27 of regulation 3 of 1872, bracket close, would stop running from the 1st of November 1949, comma, being the date of enforcement of Santhal Pargana tenancy, within bracket supplementary provisions, bracket close, Act 1949.
My lord, may kindly see para 20.
And then has referred to paragraph 20 of the apostate judgment.
Yes.
Kindly read it.
On a conspectus of relevant statute provision, on principle and in the light of aforesaid precedent, it would appear that the three distinct situations may arise in the context of perfecting title by adverse possession, where the original transfer is in contravention of the statute. For sake of clarity, these may be dealt with individually in the reverse chronological order. A. A transfer in contravention of subsection 1 or 2 of section 20 of the Act of the city, such a transfer would inevitably be after enforcement of the Act on the 1st November 1949. In view of the clear provisions of subsection 3, 4, 5 of section 20 and the related provisions of section 42, 64, 65 and 69 of the said Act, and adjudication of full bench no question.
Just a moment, वो जो date of effective लिखे हैं ना, वो that is 1st of November 1949, not 1st of April 1949.
In Bhagalpur Jain's case, year 1973 Patna, which I was just referring to, no question of any acquisition of title by adverse possession or perfecting the same in this context. First situation was that after 49, no, transfer in contravention of section 27 of regulation with regard to which the prescriptive period of 12 years has not elapsed on the 1st November of 1949. In such a case, time for perfecting title by adverse possession would in law stop running from the date of enforcement of the Act on 1st November 1949. And if the prescriptive period of 12 years is not completed before that, the right or the title would remain incoterm and cannot be perfected thereafter by virtue of adverse possession. This would follow proposition 4 of the full bench in the Bhavati Lal Jain case Supra. In such a case, the Deputy Commissioner under section 42 of the Act read with the other relevant provisions may at any time of his own motion or an application made to him pass an order rejecting the transfer, holding the transfer in contravention of the statute. Third, a transfer in contravention of section 27 of the Regulation 3 of 1872, in which the transferee has been in continuous adverse cultivating position for 12 years prior to 1st of November 1949. In view of clause A of the proviso to subsection 3 of section 27 of the said regulation, the transferee herein became immune to eviction if he had been in continuous cultivating position for 12 years. He was thus allowed to perfect his title by way of adverse position. This equally follows from proposition 5 in the Bhavati Lal Jain's case, laying down the provisions of section 20 were prospective and not retrospective in effect, and consequently there would not invalidate the transfer already perfected by adverse position under Regulation 3 of 1872, despite his repeal and substitution on 1st November 1949 by the section 20. My lord, so far as the appellant also is concerned, his case is covered under clause 3 that I have already shown. When my lord will peruse.
ये पैराग्राफ नंबर 12 कोट करेंगे देव नारायण सिंह का. The learned counsel has submitted that the case of the appellant is covered by paragraph 20 within bracket Roman 3 as Zar Ali had completed more than 12 years, had perfected the title by way of adverse possession prior to coming into force of supplementary provision of Santhal Pargana Act regulation, which came into effect from 1st of November 1949.
This was the majority view. The minority view, your worship,
Minority, we are not concerned.
gone further and has said that even the transfer to other areas is not permissible. That is the issue.
Now we have to see that what is the impact of not challenging Exhibit 7.
Yes.
Does it become a nullity?
Yes.
Or and what is the impact of ultimately not challenging the order under section 20 which was passed?
Yes.
Eviction.
These are the issues.
These are related to Exhibit 7, directly related.
Yes, directly
to Exhibit 7.
related.
So just you address that what is the consequence of Exhibit 7 read with Exhibit 2, not Exhibit 2, read with the order of eviction which was passed by the revenue authorities, which remained unchallenged.
Yes. No, that has been challenged.
No, that has not been challenged.
Yes, that suit has not been challenged.
That has not been. This suit, the order in the suit, this attained finality,
Right.
and the order of eviction passed under section 20
Right.
has also attained finality, because that was not the challenge in the present suit. The point is that irrespective of that particular adjudication, that the eviction is that you are to be evicted from the property, what is the impact on
But
this?
not make any eviction. So far as these eviction proceedings were concerned. Just that is the reason I wanted to show what are those proceedings. You may kindly see those proceedings.
Yes, we have seen it. We have recorded it.
Just.
We have recorded all one by one.
Yes, my lord has recorded, but on that day, my lord, I was not so ready. So just I want to just one second.
Which all exhibit do you want to refer to?
Yes. I want to refer to the first order passed
ये जो बॉडीलाल जैन का जजमेंट है इसका पैरा 56 भी कोट करेंगे, and this देव नारायण सिंह का this is para 20 is required to be quoted in that. Yes. Which exhibit do you want to refer to?
I 570 का ऑर्डर है.
Exhibit number.
Exhibit 6. Exhibit, exhibit 6. RER case number 26.
Exhibit 6.
Read, my lord.
Yes, it is there. Order dated. Exhibit marking नहीं दिख रहा है लेकिन I take it. 70. This is the eviction under section 20.
Yes. Your Lordship, may kindly see the cause statement. Say the name of village government. He is not a record. Rather, my lord, he had filed for my lord, eviction of say Shady and others. In others, I am there. Because my lord, their so-called have been not on record. Those have also been my lord, exhibit 5 and 5-9. Those are the exhibits my lord may kindly see. And my lord, in this proceeding was dropped on the ground that Kulfanama and all those points, and I was found in position. So the sub-divisional officer refused to exercise the jurisdiction under section 20. It was for my eviction, not the eviction of the. It was not a petition, but it was a kindly appreciation by a recorded tenant.
Is it a condition precedent that the section 20 application has to be filed by a recorded tenant?
Yes, yes.
Let us see.
My lord, may kindly see. Lordship, may kindly see section 20.
Yes. It does not say that only the recorded tenant, because the concept under the Santhal Pargana tenancy is that the property belongs to the community.
That
Right.
I will
So
be showing.
any person who is a resident of the village can initiate the proceeding under
You must have some rights. Otherwise, how?
he being a member of the community has a right, because the property under Santhal Pargana belongs to the community. It does not belong to any
Very
individual.
respectfully, I would like to say that is not the legal position. That is not.
Show me that only that the Rayyat who is the Rayyat can only initiate a proceeding.
I'm sorry. No transfer by a Rayyat of his right in his building or any portion thereof, by sale, gift or mortgage, lease or any other contract or agreement express or implied shall be valid, unless the right to transfer has been recorded in the records of rights. So unless the rights should be there in the records of rights itself.
That's right.
And
But who can initiate a proceeding under section 20? We are talking about.
And then only to the extent of which such rights are recorded. Provided that a lease of the land in submission of for the purpose of establishment or continuance of an exercise shop thereon may be validly granted or renewed by a Rayyat for a period not exceeding 1 year with the previous written permission of the but where the gifts of by a recorded Santhal Rayyat to sister or daughters are permissible under Santhal law, such a Rayyat may with his previous permission to written permission to Deputy Commissioner validly make such gift. Provided that also that an original Rayyat may with previous written permission to the Deputy Commissioner make a grant in respect of his land not exceeding 1/2 of the area of his holding or to his widowed mother or to his wife of her maintenance after death. Notwithstanding anything contained in the contrary contained in the records of rights. No right of an original Rayyat in his building or any portion thereof, which is transferable and shall be transferred in the manner to anyone, but a bona fide cultivating original Rayyat, Paragna of Taluk of Tapa, in which the building is situated. Provided that nothing in this subsection shall apply to a transfer made by a original Rayyat of his right portion thereof in favor of MI or Dhatu, provided further, a Rayat who is a member of aboriginal tribes or aboriginal castes may, with the previous sanction of Deputy Commissioner, and the Rayat who is a member of aboriginal tribes or aboriginal castes may, without such previous sanction, enter into a simple mortgage in respect of his holding or a portion thereof with any scheduled bank with the meaning of Reserve Bank of India 1934 or a society or a bank registered or deemed to be registered under the Bihar and Odisha Cooperative Societies Act 1935 or a financial institution or with a company or a corporation owned or by which not less than 51% of the share capital is held by the state government or the central government or partly by the central government and which has been set up with a view to provide agricultural credit. No transferring contravention of subsection 1 or 2 shall be registered or shall be in any way recognized and valid by any court, whether in exercise of civil, criminal or revenue jurisdiction. No decree or order shall be passed by any court or officer for the sale of the right of the right in holding or portion thereof, nor shall any such right be sold in execution of a decree or order unless the right of the right to transfer the claim will be recorded in the records of rights or as provided in this act, and then only to the extent to which the such right is sold, recorded or provided. A holding or a portion thereof and occupancy right may be sold in accordance with the procedures laid down in Bihar and Odisha Public Demand Recovery Act for the realization of loan from any of the scheduled bank within the meaning of the Reserve Bank of India or society or bank registered or deemed to be registered under the Bihar and Odisha Cooperative Societies Act or financial institution or company or corporation owned by which not less than 51% of their capital is held by the state government or central government or partly by the state government and partly by the central government, which has been set up with a view to provide agricultural credit to cultivators, but if the holding or a portion thereof belongs to the layer who is a member of an original tribes or aboriginal caste, which shall not be sold to any person who is not a member of the. Then Marat 5 is relevant. If any times it comes to the notice of the Deputy Commissioner that a transfer of land belonging to a Rayat who is a member of scheduled tribe as specified in part 3 of the schedule to the Constitution. Scheduled Tribes Order 1950 has taken place in contravention of subsection 1 or 2 or by fraudulent method, including decrees obtained in suit by fraud or collusion. He may, after giving reasonable opportunity to transfer, who is proposed to be evicted, to show cause and after making necessary inquiry in the matter, make the transferring from such land without payment of compensation and restore it to transferor or his heir, or the case of the transferor or heir is not available or is not willing to agree to such a restoration, resettle it with another layer belonging to scheduled tribe according to the village custom for the disposal of an abandoned holding. Provided that with the transferring has within 30 years of the date of transfer constructed a building or structures on such building or portion, thereof the Deputy Commissioner shall, if the transferor is not willing to pay the value of the same, order the transferee to remove the same in the period from 6 months from the order or within such extended time or the speeding exceeding 2 years from the date of the order that the Deputy Commissioner may allow. Feeling this, the Deputy Commissioner may get such building or structures ordered. Provided further where the Deputy Commissioner is satisfied that the transferee has constructed thereof a portion constructed substantial structures or building on such holding or portion thereof becoming coming to force of the last regulation 1969, he may, notwithstanding any other provisions of the Act, delegate such a transfer as the transferee as the next government to transferor or alternative holding or portion thereof as the best limit of the equivalent value in the vicinity of where the referred. These are the parameteria for the provisions of the Chota Law. My Lord, may I kindly see
The learned counsel for the appellant has submitted that
Just.
Exhibit 6, which is the order dated 22/5/1970 and was numbered as RER case number 19, case number 26 of 1968-69, reveals that it was filed by Sheikh Talim and he was not the recorded tenant with respect to the suit property, and the case and submits that the case at his instance was itself not maintainable. He has also submitted that Sheikh Talim was not party to Exhibit 7.
Which person?
Sheikh Talim was not party to Exhibit 7.
Sheikh Talim was not party to that suit. And he is not a recorded tenant
With respect to the suit property.
with respect to the suit. And basically he has filed an application in the garb of evicting me, and those recorded tenants have also been included.
The learned counsel submits that the recorded tenant as well as the plaintiff of the present case both were included as party in RER case number 26 of 1968-69, and it was alleged that the Exhibit 7 was collusive. Any allegation? And originally the subdivisional officer refused to entertain the petition.
Yes. Now, my lord, may kindly see section for it. But these are provisions, whether 20 or 42 or any provisions with respect to eviction. This is with respect to a recorded.
The learned counsel has submitted that since Sheikh Talim was not the recorded tenant, the petition itself was not maintained.
Yes. So it has no bearing so far as and those proceedings, if those orders, by virtue of which I was directed to be evicted, if those have been deleted, it will not affect the students. And one of the
He also
considerations
submits that this order was subject matter of appeal. Appeal tha na iska?
appeal and all these were the cause of action pleading.
That's right. Appeal कौन सा exhibit है?
Exhibit have 9 and 8. 8 and 8 is commissioner's order. 9 is the order of the ADC.
Appeal in exhibit 9. 9 is the final order.
ये इसी ऑर्डर के बाद इनका एविक्शन हुआ. इसमें पहला ऑर्डर में तो डिसमिस कर दिया.
The subject matter of appeal, subject matter of revision था ना?
डिवीजन तो कमिश्नर में हम लोग गए. अपील में वो
अपील का ऑर्डर कहाँ?
अपील का ऑर्डर एग्जिबिट 9.
The subject matter of revision miscellaneous appeal number 170 of 1970, which was filed by Sheikh Talim, and however the appellate authority has allowed the appeal.
And question your lordship that I want to put to myself. They basically, if they have passed order for evicting myself, but actually it was against the recorded tenant. How it is possible? At first start, the recorded tenant should go that such and such person.
No, it was restored back to the second party.
Restored back to the
Second party means the recorded tenant.
Sheikh Talim.
Yes, it was recorded back to the second party. The order of the appellate authority reveals that there was a direction to. Reveals that Sheikh Zar Ali was directed to be evicted from all the plots mentioned in Khurfanama dated 15/5/1948, and the plots were restored back to the recorded tenant who were the respondent second party in the appeal.
There was no, what I am pointing out,
It is their respondent second party, the recorded tenant was party in the revision
But
also.
it was not started at her instance.
That's right. It was not started. That I have already recorded. But there was a direction to record
She was
the
never an
recorded.
aggrieved person. That's what I'm saying. She was never an aggrieved.
The division filed against the same was also dismissed, which remained unchallenged.
Lord is well aware. Without any appeal or any proceeding, unless you are aggrieved, how can you file? So there is no meaning of such appeals and revision with respect to those recorded because they were not aggrieved.
The learned counsel submits that the entire proceeding at the instance of Sheikh Talim was not maintainable and therefore all the orders have no bearing in this case and they are nullity.
Appeal and review.
And they are nullity.
Appeal and revision.
Everything arising, all the proceedings is made at the instance of Sheikh Talim are nullity. यही आपका at best submission हो सकता है. हाँ बताइए मैडम, what do you have to say?
जहाँ तक ये भुगत बंधा और ये कह रहे हैं
भुगत बंधा का तो बात ही नहीं कह रहे हैं
और ये तूफान नाम है ये तो फॉर्जन फैब्रिकेटेड है
कहाँ से बोल रहे हैं पोर्शन का
इसमें एक चीज कहना चाह रहे थे एग्रीमेंट सिलेक्ट का कॉन्सेंट्रेशन बिल्कुल नहीं
रिकॉर्डेड टेनेंट है ये खामखा इसका जबरन कह रहे हैं कि हम पोजीशन में हैं
आप सिर्फ हमको इतना बताइए कि एग्जिबिट 7 जो सूट था राइट वो डिसाइड हुआ उसके आगे आप रिकॉर्डेड टेनेंट हैं उसके अगेंस्ट में आपने कुछ प्रोसीडिंग लिया था Did you proceed against that? You see, there are two kinds of suits. One can be filed before the revenue authority, right? And other can be filed in the civil suit. Correct? Exhibit 7, which is a suit before the revenue authority and a competent authority to decide the suit. You lost in that. Did you take any remedy against that proceeding? And the section 20 application was not initiated at your instance. Somebody else has done it, a third party. बस इतना सा का हमको जवाब चाहिए और हमको खुशी चाहिए और एग्जिबिट 7 को कंसिडरेशन है एग्जिबिट 7 का From where do you say that Exhibit 7 was collusive? Exhibit 7 का collusive का तो कोई बात ही नहीं.
जितना सा है मेरे पास डॉक्यूमेंट्स.
बस ऐसा तो ना 4 डेट में आप आते नहीं हैं और अब आपसे एक सिंपल सा सवाल पूछ रहे हैं तो आप बोलते हैं अब आपको टाइम चाहिए. टाइम नहीं देंगे हम. हो गया बहुत टाइम टेबल का कहानी. पिछला डेट का एक चीज इनका ऑर्डर रिकॉर्डेड है. आज वो रिपीट भी किए हैं और आप ही के चलते वो ऑर्डर उनको पढ़ने के लिए भी बोले क्योंकि पता है आप तो पढ़े नहीं होंगे घर से. जो इतना डिटेल 4 पन्ना का ऑर्डर था उसको पढ़ के आए.
जो दिया बस
वही ना. एडजर्नमेंट ऑर्डर भी नहीं पढ़ के आते हैं, कोर्ट में रहते भी नहीं. हम आपके घर तो नहीं आ सकते हैं एडजर्नमेंट ऑर्डर लेकर कि मैडम प्लीज थोड़ा पढ़ लीजिए इसको. ऐसा तो नहीं बोल सकते ना. ऑर्डर हुआ, अपलोड हो गया, आपके लिए रिपीटेड टाइम हुआ, इससे ज्यादा तो आपके लिए नहीं कर सकते. यू जस्ट आंसर दिस.
अकॉर्डिंग टू लॉ जो आपको ऑर्डर करना है इसमें
तो यही लिखा रहता है कि आपका यही सबमिशन है. जितना सबमिशन करिएगा उतना लिखाएंगे. You just whatever you will submit, I will record it.
पार्टी से भी हमको ज्यादा मतलब कुछ है ही नहीं कि एक बार भी टेंशन से नहीं हुआ है.
इससे क्या मतलब है? रिकॉर्ड आपके पास है, पार्टी का क्या काम है? आपसे ज्यादा पार्टी लॉ थोड़ी जानता है. वकालतनामा इस तरह के प्रोसीडिंग में साइन करने के पहले बहुत सोच समझ के साइन करना चाहिए क्योंकि हो सकता है नेक्स्ट जनरेशन तक इस कहानी को लेके जाना पड़े. वकालतनामा फाइल करके आप ये नहीं बोल सकते पार्टी नहीं है, हम नहीं, रिकॉर्ड है। और क्या करेगा पार्टी? पार्टी को समझ आ रहा है क्या ये इंग्लिश में क्या क्या लिखा है सेक्शन में? आपको जो आर्गुमेंट करना है आप कर लीजिए, ठीक है? क्या बोलना है मैडम आपको? आप जितना बेस्ट आर्ग्यू कर सकते हैं वो हम लिखा रहे हैं आपकी तरफ से, क्योंकि आप तो कुछ बोल ही नहीं रहे। यहाँ तो यही कहानी है, जज को पिटिशनर का भी आर्गुमेंट करना होता है, रेस्पोंडेंट का भी आर्गुमेंट करना होता है और अपना फाइंडिंग भी देना। झारखंड हाईकोर्ट का यही स्टोरी है।
पेज नंबर 4 लिखा चाहिए।
फोर ऑफ द किसका? एपीलेट कोर्ट्स ऑर्डर बताइए, हम वही पर।
Dated 15/5/1948 is further fabricated one. The plaintiff did not never claim possession in property. The story of Gadbandha in favor of Ram Nagina has been fabricated and the suit being polluted. The suit was contested by S.P. Sudham. The intervener depended to move to for his claim, but pleading S.K. Zar Ali and Talib Ali were the brothers. The property was partitioned months earlier to settlement. All the shareholders were in their exclusive separate position. Bibi Gatina and Hanifa were also the daughters of Sheikh Sanju. Kamruddin was the successor of Hanifa. The property which came his share of Sheikh Abdul was possessed by his daughter Bibi Jaitun and Bibi Khan. The suit is bad for non-vendor of their successor. The property that is plot of 341, 342, 344 and 56 has yet not been partitioned. He denied the exclusion of any Urfanama premium. और ये आपका नीचे ये है in written statement on behalf of the intervener defendant S.V. Sudham following the neurological table has been relied upon. For the sake against the same has been reproduced herein below. Upon this the learned board below provised that decide the matter and dismiss the suit. neurological table है ना, कभी ये लोग पोजीशन में आ रहे ही नहीं, सब मनगढ़ंत कहानी है। कभी नहीं आया। जेनोलॉजिकल टेबल जो है ये
Learned counsel for the respondent. Has submitted that has referred to paragraph 4 of the appellate court's judgment and has submitted that it was the specific case of the contesting defendant who were successors of Sheikh Sanjo. That Kurfanama dated 15/5/1948 was forged and fabricated, and the plaintiff never came in possession. The story of Kurfanga in favor of Ram Nagina was fabricated, and the suit was collusive. The suit was contested by Sheikh Sujan, the intervener defendant, who put forth his claim by pleading that Sheikh Zar Ali and Talim Ali were the brothers, and the property was partitioned much earlier to settlement. And further, all the shareholders were in exclusive separate possession. It was also asserted that Bibi Gafina and Hanifa were also the daughters of Sheikh Sanjo. Kamruddin was the successor of Hanifa. The property came in the share of Sheikh Abdul, who was in possessed by his daughter Bibi Jaitun and Bibi Kali. And he denied the execution of any Kurfanama. Intervener कौन है इसमें? Who is the intervener?
Sujan, say Sujan.
The Kurfanama was executed by Sheikh Sujan. Kurfanama कौन execute? कौन किसने किया?
Kurfanama है छेदी,
शेख छेदी,
मोहम्मद गफीना और बीबी जैतून.
The Kurfanama, during the court proceedings, it transpired that the Kurfanama was executed by
Sheikh Chedi.
Sheikh Chedi and
Pesman,
son of Sheikh Sanjo,
Mustafa और मोहम्मद गफीना.
Mohammad Gafina and
जोधे शेख अब्दुल.
Wife of Sheikh Abdul and
बीबी जैतून.
Bibi Jaitun,
जोधे शेख कमरुद्दीन.
wife of Sheikh Kamruddin. And the intervener in the present case was, who was the intervener?
Sujan. Perhaps he कमरुद्दीन का
The intervener was Kamruddin.
रेड कमरुद्दीन का होगा.
Naam?
शेख सुजान son of Red
Sheikh
Kamruddin.
Sujan, son of late
कमरुद्दीन.
Kamruddin. और क्या बोलना मैडम बताइए? He submits that the courts have rightly come to a conclusion that the Kurfanama itself was forged and fabricated. And therefore, it is submitted that no right could have flown to the appellants through Kurfanama. That's all. और कुछ बोलना? Appellate court ने इस Exhibit 7 को कहीं discuss किया है? Because he has repeatedly argued that Exhibit 7 has not been discussed by the appellate court at all. Has it been discussed anywhere? During the course of hearing, the learned counsel for the respondent could not point out any discussion with respect to Exhibit 7. Exhibit 7 में कौन-कौन पार्टी थी एक बार उसको नोट In response, the learned counsel for the appellant has submitted that in Exhibit 7, that is statute number 125 of 1968, the plaintiffs were Sheikh Kheti, B.B. Gabina and B.B. Jaitun, and the defendant was Zar Ali. And all the three, and they were the three persons who had granted the Khutbana. That's all. So you can do it. Others. अब तो हो गया, अब आपका क्या written submission? आपका हर चीज रिकॉर्ड करना। अब no written submission is actually
Automaton messenger is Title 1257, CMP 391 of 2026.
who's for the petition?
Unfortunately, when we went to we haven't filed I mentioned in Bharat 3 lordship, so that defect will not remove the lordship, so I take some
You see, the time for removal of defects was extended till 20th March 2026. The earlier order was a preemptory order. So that preemptory order stood extended. Now your second appeal again stands dismissed. So you have to file an application for restoration of second appeal. Then the second appeal has been dismissed. 3 weeks time for what? I do not know. क्या यहाँ पे क्या फाइल करते हैं? Where is the order of the second appeal? The second appeal.
Here is total the same.
CNP number 391 of 2026. The Learned Counsel for the petition is present. This petition has been filed for modification of order dated 12/2026 passed in CNP number 295 of 2008. Whereby there was a direction to remove the defects and the time granted by the order dated 21/10/2005 in SC number 630 of 2004 was extended till 28 March 2026. This court finds that the preemptory order which was granted by order dated 21/10/2025 to remove the defects in the second appeal number 630 of 2003 was extended till 20th of March 2026. And apparently the order remained preemptory. But even till the extended time, the defects were not removed. Consequently, second appeal number 630 of 2004 as against to dismissed for non-removal of defects. The order passed in CMP number 295 of 2008 has taken its effect. And therefore, the order dated 12/26 passed in CMP number 295 of 2008 cannot be modified. The second appeal number 630 of 2004 stands dismissed on account of non-compliance of order dated 12/2026. At this counsel for the petitioner has submitted that a liberty may be reserved with the petitioner to seek restoration of SC number 630 of 2004. In view of the aforesaid order, the petitioner may take steps as may be permissible under law. And this order will not be an impediment. Understand?
From supplementary list, permission item 4, WPS 1212 of 2015.
Yes.
Learned counsel submitted the case of the petitioner similarly that of one Marjit Marsin, whose order of termination has been ultimately quashed by this court by its judgment so and so in appeal number so and so. He submits that the petitioner also moved this court earlier in WPC number so and so and other analogous cases, and in paragraph 16 of said judgment the reference of case of Marjit Marsin has been mentioned, and ultimately the order of termination of the petitioner was set aside in the batch of cases. He has also submitted that there was an observation that if the authorities intend to take any action against the petitioner as personally charged, they would be at liberty to take action against all or any of the petitioner, but only after serving them charge and conducting inquiry
and by giving that the individual petitioner a reasonable opportunity of being heard in accordance with the principle of natural justice. The learned counsel submits that the charge which was subject matter of consideration in WPS number so and so was again issued to the petitioner, and ultimately the petitioner has been terminated. The learned counsel submits that there is no discussion of the similarly situated person, namely Ranjay Kumar Singh, in the impugn order. He has further submitted that Ranjay Kumar Singh was prosecuted again by issuing a charge memo in similar manner, and his service was terminated because subject matter of litigation is taken on WPS number 2148 of 2010 and Section 15, and the said writ petition was disposed of by directing the SP Jharkhand to consider the super's implementation of Ranjay Kumar Singh and pass a recent order in accordance with law within a period of 8 weeks. It was further observed that if the final decision is taken by the superintendent of police, no possible steps shall be taken against Ranjay Kumar Singh. And counsel submits that the final order in this petition was passed on 23/7/2010, and the respondent did not take any action thereafter, and Ranjay Kumar Singh is still working. He submits that many similarly situated persons who were with the petition in the batch case of WPS number 403/2007 and another analogous cases are still working, but only the petitioner has been left out. He submits that only 932 persons were excluded from appointment in the entire list, and the name of the petitioner does not figure in 932 persons. Therefore, there is no reason to keep the petition out of service. And consequently, the respondent pays for adjournment, preparing certain case and to seek instruction as to whether all the persons who were involved in WPS number so and so and other cases and Ranjay Kumar Singh is pointed out as a concept of petitioner are working in the department and under what condition they are working. A supplementary affidavit will provide to this.
Why does supplementary affidavit? What is your stand?
That Ranjay Kumar Singh has been appointed pursuant to the order passed in the LPA, and he is still working.
What about others? What about others?
Others details has not been given.
So his statement is correct because you have not responded it adequately and appropriately.
One of the other person also this order and might be joined up. I don't know which is Jai Ram Singh. He is also among the analogous cases. He is supposed to be, he was my client, and his order recently his punishment order has been set aside in respect of some another offense. He is working in the police department and working till date. Only this petitioner has been left out of the entire analogous cases that petitioners may not. There is no dissimilarity between them and me.
So your disciplinary proceedings arising out of your charge memo has been taken to a logical end?
Yes, I have been dismissed from service.
Okay. And
in their cases, their dismissal, Ranjay Kumar Singh, Section 15 order will kindly dismiss. In the similar fashion, Ranjay Kumar Singh was also dismissed by the second, and in this order has been passed, Section 15, page number 74. In the final decision is taken by SP Jharkhand, no possible steps shall be taken against the petitioner.
So what happened in this LPA?
LPA has been directed to LPA order is also there, madam.
Where is that?
Yes, ma'am. LPA number Section 9.
There was an interim order in his favor. And then
LPA is punishment order was set aside, dismissal was set aside.
what is the ground for such dismissal?
Yes, ground. Section 9 is
Yes.
this letter by time is directed in judgment in WPS number whereby learner signature dismiss the regular commission and refuse to interfere with the Jharkhand district order number so and cancelling the appointment of the applicant to the post of constable. The case of the applicant is that pursuant to the article number 1/2004 published in the newspaper for appointment of constable, the applicant applied for the same and allotted roll number 72 after fulfilling the criteria and educational qualification. Applicant appeared in the case and was declared successful. It is stated that the chairman of the selection board, after following the entire process, issued letter of appointment dated so and so. The applicant joined the post of constable on 10/4/2007. However, after a month, the social notice was issued that the applicant, but later dated so and so by Superintendent of Police Jharkhand, asking him to supervise as to why his appointment not be cancelled because of overwriting and interpolation in the master chart.
So
This
your
is the
facts
same.
are same?
Yes, everything.
Dates are also same?
Yeah, everything, सब same.
Okay.
मेरा भी यही है.
Then
The applicant said to have filed detailed reply denying and disputing
in the allegation made in the superintendent stating that he was appointed after being declared successful in the interview on physical test. मेरा भी same है. The reply so filed by the applicant was not accepted and he was dismissed from service by order of the so and so. That counsel appealing for the applicant has stated the impugn order of dismissal of the applicant from the service and also the impugn judgment passed by the learned single judge. Learned counsel submitted a learned single judge has not considered that it was only after holding inquiry and with regard to the genuineness of the appointment and after the decision rendered by the division bench of this court in Krishna Ji and others, the applicant was asked to join the service by later dated so and so according to learned counsel the dismissal of the applicant and from service on the basis of said inquiry report is wholly illegal and without jurisdiction.
आपका भी यही सेम
सब same.
Then
Mr. Ramakrishna Loha's senior and standing counsel on the other hand submitted that it was only on the basis of interpolation found in the master chart the appointment of some persons have been cancelled after holding inquiry. As noticed above, the applicant was dismissed from service on the basis of inquiry conducted by IG of police on the basis of detailed memo number so and so. A copy of dismissal discharge order has been annexed 7 to this petition. It appears that against the order of cancellation of appointment of other candidate on the basis of said inquiry report dated so and so, several writ petitions was filed in the year 2006 challenging the said cancellation of appointment. Those writ petitions were finally held by division bench of this court. At this juncture, I would like to refer paragraph 4 of the decision from which it is evident that appointment of some of the candidates were considered on the basis of inquiry report dated 31/10/2005. Said judgment is quoted here in below. Now next page I am done now. The division bench of this court, after considering the entire facts of the case in my appointment, this is dealing Krishna Ji order, madam.
that's right.
Now para 7.
Yes.
The aforesaid judgment was delivered on so and so. It was only after the aforesaid judgment since the applicant was not identified to be in the category of 932 persons. I am also not identified in 932 persons. He was allowed to join the post of constable by so and so pursuant to a procedure the applicant submitted his joining and he was allowed to join on the post of constable. Surprisingly, the applicant was again dismissed from service on the basis of same inquiry report dated so and so which is evident from the impugn order of dismissal. All these facts have not been considered by learned single judge.
You have also been dismissed on the basis of same inquiry.
On the same
New inquiry.
वो भी हम दिखा देते हैं दोनों इंक्वायरी रिपोर्ट भी हम लगाए हुए हैं दोनों से Beside the above several petitions were filed in the case number so and so, filed so and so, so and so by considering the entire facts of the case discussed herein above the impugn order of dismissal of the applicant from service cannot be sustained in law for the reasons above the appeal is allowed and the impugn judgment passed by the Learned Single Judge and also the impugn order of dismissal of the applicant from service is set aside. We further that the respondent to allow the applicant to join the post of constable, but it is made clear that the applicant shall not be entitled to any damages from the date of dismissal till the date of reinstatement. So this was the order.
So far as your case is concerned, everything is identical, but your dismissal is not on the same inquiry.
Dismissal is also on the same ground, madam. I am saying
Same ground or same inquiry?
same, madam. The charge sheet of दो राउंड हम डिस्मिस हुए. पहले बार जो हमें चार्जशीट दिया गया और सेकंड दोनों में एकदम सेम चार्जेस है सिमिलर. रंजय कुमार सिंह और बाकी लोग जो फर्स्ट राउंड में मेरे साथ आए थे डेवलपर्स केसेस में सबको नौकरी दे दिया गया. उसमें 7-8 लोग थे सिवाय बस हमको छोड़ दिया.
So you were there in annexure 7.
Yes, annexure 7.
And you were not in the amongst those 9
No. It has also
so your fact is identically placed.
Everything.
Irrespective of fresh inquiry or whatever.
Yes. 4032 annexure 7 का पहला केस.
Yes, respondent, you just tell me, is he amongst the 932 candidates? How is the case of the petitioner different from the other cases?
The case of the petitioner is different from that of Ranjit Kumar Singh, the LPA order which was passed. If your lordship would come to page number 53 of the LPA order, the operative portion, paragraph 7, page number 53 of the writ petition.
Yes.
Yes. The aforesaid judgment was delivered on 10/11/2006. It was only after the aforesaid judgment, since the appellant was not identified to be in the category of 932 persons, he was allowed to join the post of constable by letter dated 10/4/2007. Pursuant to the aforesaid letter, the appellant submitted his joining and he was allowed to join on the post of constable. Surprisingly, the appellant was again dismissed from service on the basis of same inquiry report dated 31/10/2005. Now, the case of the present petitioner, if your lordship would come to the writ court's order, whereby which is at page number 47, operative portion, page number 47. The operative part of LP order was that since it was on the basis of the same inquiry report dated 31/10/2005, therefore the appeal was allowed, Your Lordship. Now in page number 47, when the petitioner approached this court in the writ proceedings, the operative part is at page paragraph 16 and 17. In case of Ranjay Kumar Singh, identical issue came up before the court for consideration, where the writ petitioner was admitted not identified to be in the category of 952 excluded persons, and he was allowed to join the post of constable, and later his appointment was terminated. The division bench had caused the impugned order of termination. Now, in light of the above facts and circumstances and discussions made, these writ petitions are allowed. The order impugned in WPS number so are hereby quashed. Now, liberty was given to us. The respondent authorities shall allow the petitioner to join their post on the basis of the letters of appointment given to them. That we have done. However, if the respondent authorities intend to take any action against the petitioner on any specific charge, they would be at liberty to take any action against all or any of the petitioner, but only after serving them charges and conducting inquiry by giving the individual petitioner a reasonable opportunity of being heard in accordance with the principle of natural justice.
So did you
Now,
serve them
yes.
charge? Where
Now,
is the
Your
charge memo?
Now, Your Lordship would come to the new charge memo after passing of this order at page number 54, which we have served. This is the new charge memo. As per the liberty granted by the Red Court, we have issued him this memo of charge, which is at Annexure 10, page number 54. And a detailed inquiry was conducted.
Just a moment, let us see the charge. Charge पढ़िए ना?
Yes, sir.
उनको पढ़ने दीजिए, चार्ज उनका है ना, पढ़ने दीजिए।
औपचारिक पुलिस 1377 वीरेंद्र कुमार सिंह विज्ञापन संख्या 1/2004 दिनांक 15/5/2007 को हजारीबाग जिलाधीश संख्या 1094/2007 के द्वारा अस्थायी तौर पर पुलिस के पद पर पुलिस संख्या 1420 के साथ नियुक्त हुए तथा आपको जिलाधीश संख्या 232/2010 के द्वारा पुनः माननीय उच्च न्यायालय के आदेश पर पुनः सेवा में पुलिस संख्या 1377 के साथ बहाल किया है।
इससे क्या है, सब बैकग्राउंड है, चार्ज बताइए। It's just a background.
थर्ड, आपकी पात्रता की शर्तों के तरीकों, उम्मीदवार बनने की दस्तावेजों एवं मास्टर चार्ज की जांच के क्रम में पाया गया है कि जिस पृष्ठ पर आपकी विवरणी दर्ज है उस पर 5 उम्मीदवारों के लिए निर्धारित स्थान को विभाजित कर क्रमांक ए जोड़कर 9 उम्मीदवारों को समायोजित करने का प्रयास किया गया है।
9 में से वो भी है रंजन कुमार जी, है ना?
यस लॉर्ड।
आगे बढ़ो।
जो विभिन्न लिखावट में है, जिस पर पुलिस महानिरीक्षक बोकारो के कार्यालय ज्ञापन 994 डेटेड 31/10/2005 द्वारा निर्गत आदेश के द्वारा कुल 139 उम्मीदवारों की पात्रता फर्जी पाते हुए अयोग्य घोषित किया गया है। इस प्रकार
ये जो 139 है इसमें रंजन कुमार सिंह।
This is apart from 932 candidates.
Yes, yes, certainly. Apart from 9.
Yes, sir.
His name is not there in the 932 candidates.
Yes.
That is for sure.
इस प्रकार कुल सूची में से अयोग्य पाए गए उम्मीदवारों में आपका क्रमांक 3328 जिला भी दर्ज है। Now 7 number memo charge। आपको पूर्व में चयन समिति द्वारा रद्द की गई पात्रता तथा
नहीं आगे पढ़िए, 4 भी पढ़िए, सब पढ़िए।
इस संबंध में पुलिस अधीक्षक कोडरमा सह अध्यक्ष चयन समिति के कार्यालय के ज्ञापन 1447 दिनांक 24/6/2007 के द्वारा आपकी पात्रता रद्द करने हेतु निर्देश दिया गया। फिर इसमें आपकी संलिप्तता प्रदर्शित होती है तथा आपको लाभ पहुंचाने के लिए इस प्रकार की गड़बड़ी आपके द्वारा कराई गई है। 6 आपके द्वारा दायर रिट याचिका WPS 4032/2007 वीरेंद्र कुमार सिंह बनाम झारखंड राज्य के द्वारा पारित आदेश के आरोप में आपको पुनः पुलिस के पद पर बहाल किया गया, जिसमें बहाली के पश्चात नेचुरल जस्टिस के तहत पुनः कार्रवाई करने का आदेश प्राप्त।
ये नेचुरल जस्टिस के तहत तो नहीं है आदेश करने का। आपको however if the respondent authority intended to take any action against the petitioner or on any specific charge, they would be at liberty to take any action against all or any of the petitioner, but only after serving them charge. The same charge पे तो नहीं था, खाली natural justice का violation का कहानी नहीं है। It is not on account of only violation of natural justice.
फर्स्ट चार्ज है नेक्स्ट फर्स्ट चार्ज होता है वो भी एग्जैक्ट सेम उसको भी पढ़ लिया जाए पेज 36
Natural justice का तो violation का कहानी नहीं है. You have to specific charge must be made. You are proceeding. You are assuming as if the court has allowed the writ petition on account of violation of principles of natural justice. If it was not allowed on the point of violation of principles of natural justice, but what is it are you writing? You have not given him a fresh charge. You are proceeding in the same charge.
Your Lordship, we could not
Understand.
no, Your Lordship, we could not rewrite the new charges again after passing of the report order. The
Why
charge,
it is that liberty was given to you?
because the charge was very specific. We
You
could
should
not
have
bring a
challenged
new.
that order. You should have challenged that order that on the same charge you want to proceed. There is a specific direction that you have to proceed on the basis of that charge. What else? Read it further.
7. आपको पूर्व में चयन समिति द्वारा रद्द की गई पात्रता तथा बर्खास्त करने के लिए गए निर्णय के अनुपालन में बर्खास्त करने से संबंधित नोटिस देते हुए 1 सप्ताह में जवाब मांगा गया था। आपके द्वारा दिया गया स्पष्टीकरण संतोषजनक नहीं पाए जाने पर आपको जिलादेश संख्या 1321/2007 ज्ञापन 4316 dated 12/6/2007 के द्वारा सेवा से बर्खास्त किया गया था। 9. इस प्रकार आपके द्वारा गलत तरीके से फर्जीवाड़ा करते हुए सिपाही पद पर के प्रकार बहाल होने।
Now you tell us what is the finding thereafter. You see, you have proceeded on the same charge. You have not given him any fresh charge. Pursuant to the order of the court. Correct?
After passing of the review.
You have not done it. Okay. What is the finding?
The finding is that
Where is the role of the petitioner in this interpolation of your records? You should show that there was some role of this petitioner in interpolation of your records. What is the finding?
finding is that you got to page number 108, the inquiry report.
108.
Operative part.
Annexure number is
Annexure number 12.
annexure 12. Okay. Pardon? क्या पढ़ना है?
The last portion at page number 108. यहाँ यह विदित हो कि अपचारी के विरुद्ध गठित आरोप अभिलेखों के आधार पर गठित है और इनके अभिलेखीय प्रमाण मौजूद हैं। चूंकि मैं निर्देश अनुसार इस विभागीय कार्रवाई का संचालन व जांच अपचारी के विरुद्ध गठित आरोपों के आधार पर कर रहा हूँ, न कि इस संबंध में माननीय उच्च न्यायालय द्वारा दिए गए आदेशों के आधार पर। फलस्वरूप मैं अपचारी के विरुद्ध गठित उपरोक्त 9 आरोपों पर ही मात्र विवेचना कर रहा हूँ।
ये 9 आरोप कौन सा है?
वन पॉइंट वाइज एक दो तीन जो
पेज नंबर 16
वो आरोप कहाँ है? हाई कोर्ट में रीट फाइल करना आरोप है? Is it a charge?
There are only 2 charges.
There is no charge because no fresh charge has been given to him. You are proceeding against him in the same charge.
But we were given liberty to, we can proceed on any specific charge. The
No
liberty.
fresh charge has been given. You assume that there was violation of natural justice and you proceeded. And he is saying, this inquiry officer is saying there are nine charges. आगे बढ़िए.
यहाँ यह उल्लेख करना आवश्यक है कि यह सारा मामला तत्कालीन पुलिस महानिरीक्षक बोकारो के ज्ञापन 994 डेटेड 31/10/2005 के माध्यम से इस संबंध में जांच प्रतिवेदन पर आधारित है। इस जांच प्रतिवेदन में अपचारी के विरुद्ध गठित उपयुक्त आरोप संख्या 1 से 5 तक तथा आरोप संख्या 7 से 9 तक स्वयं स्पष्ट एवं प्रमाणित होते हैं। यह प्रतिवेदन इस संचिका में संधारित है जो प्रदर्श 4 के रूप में इंगित है तथा पुलिस अधीक्षक कोडरमा का ज्ञापन 1447 डेटेड 24/6/2007 प्रदर्श 5 के रूप में अंकित है एवं इस संचिका में संधारित किया गया है। आरोप संख्या 6 जो माननीय न्यायालय में दायर याचिका संख्या 4032 में माननीय न्यायालय द्वारा अपराधी को पूर्ण नियुक्त करने संबंधित पारित आदेश से संबंधित है एवं प्रदर्श 3 के रूप में संचिका में
क्या चीज में दोषी पाते हैं? That he has committed some fraud, some interpolation. Is there any finding that he is a party to this interpolation of your records? There is no finding. An identically placed person has been taken back.
in this inquiry report
There is no finding.
प्रिंसिपल ऑफ नेचुरल जस्टिस से बात कर रहे हैं। इसी इंक्वायरी रिपोर्ट में अभियोजन में कोई साक्ष्य लिया ही नहीं गया। नो एग्जामिनेशन ऑफ विटनेसेस, नो क्रॉस एग्जामिनेशन, सीधे मेरा स्पष्टीकरण को कोट करके उनको गिल्टी कर दिया। ये पेज 60 नेक्स्ट 12 पे पेज सेकंड अभियोजन साक्ष्य कुछ नहीं, नो एग्जामिनेशन, नो क्रॉस एग्जामिनेशन, बस डॉक्यूमेंट कोई दिखाया कुछ लिख दिया एक लाइन। दिस इज द कार्डिनल प्रिंसिपल्स ऑफ नेचुरल जस्टिस फॉलोड बाय देम।
Nothing was exhibited. What was the already on record and the order has been passed on that. One last question. Ms. Ranjan Kumar Singh was amongst the 9 persons whose name was interpolated in this 9 लोगों का नाम दिया है ना? 130. For the learned counsel appearing on behalf of the parties, this petition has been filed for the following reasons. The learned counsel for the petitioner has submitted that the petitioner had participated pursuant to advertisement published in the daily newspaper dated 13/1/2004 and was declared and was allotted roll number 3328. And after completing the procedure, he was declared successful. And a letter bearing memo number 2520 dated, letter of appointment bearing memo number 2520 dated 3/4/2007 was also issued. Remeasurement of the petitioner was also done, and after completing the medical test, he was allocated police brass number 1420. However, soon thereafter, on 26/5/2007, a show cause notice was issued to the petitioner as to why his services may not be dismissed. The learned counsel has referred to annexure 4 and has submitted that it was alleged therein that
interpolation in master chart.
That there was interpolation of master chart in different writings, and name of 9 persons were 9 persons were included. And the petitioner responded to the same. However, he was dismissed from service on 12/6/2007. He submits that all similarly situated persons had filed a petition before this court, including the petitioner, which was WPS number 4032-3374 and 3726 of 2007. and the order of dismissal was quashed by the order dated 16/12/2009. Pursuant to the order passed in the late court, the petitioner was reinstated by the order dated 12/1/2010. The learned counsel has referred to the order passed by the late court as contained in NHS 7 and as referred to paragraph 17, 16 and 17 thereof, which is quoted as under. The learned counsel submits that ultimately the learned counsel submits that on the basis of inquiry report, the services of the petitioner were dismissed along with others on the charge that they were the beneficiaries of mall practices, and total number of such candidates were 139. He further submits that the aggrieved candidate whose order of dismissal was challenged in WPS number 3940 of 2007. 3940 का ऑर्डर था, वो नहीं लगाया.
वही रंजन कुमार सिंह ने पहला 3940 डिस्मिस हुआ था, जो एलपीए में सेट असाइड हुआ.
Right. Which was filed by Ranjay Kumar Singh. The said candidate filed LP number 296 of 2007, and the LPA was allowed. The learned counsel has submitted that all the facts stated in the LP number 297 of 2007 is identical as are similar as that of the present petitioner. The learned counsel has referred to the findings recorded by the learned LPA court in paragraph 7 to 10 as under. He submits that, however, in view of the order passed by this court in the case of the petitioner and analogous cases in WPS number 4032 and other analogous cases, the petitioner was served with a charge sheet dated 5/4/2010 by memo number 1437 as to why the petitioner may not be dismissed. The petitioner has placed the charge memo and has submitted that it contained altogether 9 paragraphs, most of them giving the background of the case and the earlier allegation which was levelled against the petitioner. He submits that thereafter the petitioner responded and denied the allegation. He has then referred to the inquiry report and has submitted that the inquiry report reveals that no witness on behalf of the defendant, on behalf of the department was examined. He further submits that so far as the inquiry report is concerned, the inquiry officer has treated each one of the paragraphs as a charge, and ultimately only held that the petitioner was guilty. He submits that there is no finding that the petitioner had any role in the alleged interpolation. The learned counsel submits that the fact remains that identically placed person, including Ranjit Kumar Singh, has been taken back by the respondents. And others have also been taken back, but only the petitioner has been left out. The learned counsel has relied upon the judgment passed by Honorable Supreme Court reported in the case of Civil Appeal number 1334 of 2013, in the case of Ardin Yadav versus State of LP, paragraph 12, and has submitted that the doctrine of equality applies to all those who are equally placed. The learned counsel submits that the case of Ranjan Kumar Singh and the petitioner are identically located. He has further submitted that, pursuant to the order of this court, no fresh memo was issued, no fresh charge was framed against the petitioner. It was the department was proceeding on the basis of the same and similar charges which were leveled against Ranjan Kumar Singh, and ultimately Ranjan Kumar Singh got the final relief from the LPA court. And before the LPA court, it was recorded that on the basis of same inquiry report, Ranjan Kumar Singh was dismissed. The learned counsel submits that in the present case there has been no inquiry worth named, and therefore the case of the petitioner is identically similar. The learned counsel further state has opposed the prayer and has referred to the order passed in the case of the petitioner, and has submitted that pursuant to the order, the liberty was given to the department to proceed against the petitioner and other similarly situated persons. He has submitted that in the case of Ranjit Kumar Singh, on the basis of the earlier inquiry report itself, he was dismissed, and therefore the LPA court had granted the relief to Ranjit Kumar Singh. The learned counsel has further submitted that the petitioner was proceeded afresh and inquiry report was found against him, and ultimately the petitioner has been dismissed. However, during the course of hearing, no distinguishing feature apart from the apostate with respect to the nature of allegation against Ranjan Kumar Singh and the petitioner has been pointed out by the learned counsel for the respondent. It is relevant to note that an order dated 7/11/2025 was passed by this court with respect to parity between Ranjit Kumar Singh and the petitioner, pursuant to which supplementary counter-affidavit has been filed. But with respect to the nature of allegation against the petitioner and Ranjit Kumar Singh, no difference has been pointed out. There is no difference. It is further not in dispute that pursuant to the fresh inquiry, no evidence was laid from the side of the department. Correct?
Not in the inquiry.
As is apparent from the inquiry. And no fresh charge memo was issued. Rather, the authority proceeded as if this court had granted liberty to the respondent to follow the principles of natural justice. The authority had proceeded on the same charge which was earlier leveled against the petitioner and others, including Ranjan Kumar Singh. After hearing the learned counsel for the parties and considering the opposite facts and circumstances, this court finds that although a liberty was given to the respondent to proceed against the petitioner, against the various petitioners, including the present petitioner, to take action against them on any specific charge only after serving them the charge and conducting inquiry by giving the individual petitioners a reasonable opportunity of being heard. A fresh charge memo was issued consisting of 9 paragraphs, and most of the paragraphs were relating to the background in which the charge memo was being issued. The petitioner was not served with any fresh allegation, rather the department proceeded against the same allegation which was given to the petitioner earlier. This court further finds that so far as the inquiry is concerned, no witness or material were no witness were produced before the authority, and rather no evidence was led from the side of the department. The inquiry officer dealt with each of the paragraphs and simply recorded a finding that the petitioner was guilty of the charges. This court finds that the fresh inquiry is also perfunctory and is not in accordance with law. Further, this court also finds that the respondents have not been able to distinguish the case of the petitioner as compared to that of Ranjit Kumar Singh, who also faced with identical charges as that of the petitioner, in spite of specific opportunity given to the respondent. In view of the aforesaid judgment relied upon by the petitioner in the case of civil appeal number 1334 of 2013, this court is of the view that the petitioner is entitled to similar treatment as that of Ranjit Kumar Singh. This petition is accordingly allowed on both the grounds of parity as well as the fact that practically no fresh inquiry was conducted by the department in connection with the same allegations which were leveled to the petitioner and others by memo dated 31/10/2005. So you will be reinstated without packages.
Because
Others were not granted.
Shall not be entitled to packages.
But he has been reappointed in the year 2010 and I am out of service till 2046.
Same बस उतना ही देंगे.
At least 25-50%.
1% देंगे.
तो other benefits promotion उसका.
Identical कुछ नहीं.
Other benefits जो होते हैं.
जो उसका और होता है.
तो फिर तो ये fresh appointment है.
Fresh appointment है ही नहीं.
ये fresh appointment है.
नहीं. Fresh appointment कैसे हो? The operative portion of the judgment passed in the case of Ranjit Kumar Singh in LPA is quoted as under. The petitioner is granted the identical relief.
Include order first.
Include orders are first. The state is directed to comply this order within a period of 15 days from the date of communication. 15 दिन में आप कंप्लाई हाँ उसके बाद क्या करना है तो इसीलिए जल्दी से एनपीए करते करना है तो 15 days बहुत है. It will take some time for correction, but this is how it is produced.
Auto termination case from daily list item 31, contempt was 669 of 2023.
Yes.
The cabinet decision has already been taken effect and we have issued a resolution on 21/4 and we have sent it to the apartment in the processing and payment matters.
So order stands compliant. Order stands compliant.
The order was to ensure payment, so we have ensured and sent it to the order, but if it can be posted up after 2 weeks or so, my lords, I do think the order will ensure the payment.
So all needful has been done?
Definitely.
Yes?
Payment only remains.
Only payment remains? How much time your officer needs to do the payment?
We have already sent to the order, as per this we have already sent.
Who are they?
Yeah.
Who are they? What is your designation?
He is the secretary, Mr. Rao, Principal Secretary Mr. Rao.
And you? You are with him? You have come with him?
Well, his presence was not ordered, he is just assisting us.
So when the counsel for the parties are present, Mr. Rahul Purwar, the secretary,
Principal Secretary.
the principal secretary,
Higher
higher
and technical.
and technical education is present before this court pursuant to the last order. It has been submitted by the opposite party that needful has been done to give the relief to the petitioner in terms of the order passed by this court, and the memo number 395 dated 21/4/2026 has been produced before this court, which is taken on record. A copy of the said memo has also been handed over to the counsel for the petitioner. The counsel for the petitioner appears to be satisfied with this memo. However, she submits that the payment is yet to be made. To this, the counsel for the opposite party submits that if the matter is adjourned by how many weeks do you need to make the payment?
2 weeks.
If the matter is adjourned by 2 weeks, the required payment will be made directly in the account of the petitioner, and appropriate affidavit will be filed. Post this case on 15th of May in the supplementary cause list. हो जाएगा? या छुट्टी के बाद लगे? 12th of June. 12th of June in the supplementary cause list. If the affidavit regarding payment is filed prior to the next date, the Mr. Rahul Purwar, the Secretary, Higher and Technical Education, need not remain present on the next date, as the case would practically become infructuous. Post on 12th.
From daily list item 3, Professor WPS 3754 of 2023.
Where is the respondent? Respondent. Readings are complete. Where is the respondent? Have they responded to the last order dated 6/26?
Not filed.
Where is the state? Yes, are you there in this case?
Mr. Mithilesh, I'll just inform you short.
Yes, where is he?
I'll
Call
just-
him, please. Please.
Pray for lots of which time for filing, sir.
Why have you not filed it?
Because we have already written a letter or some, it is being prepared or some filing for this.
Now they are in touch of the retirement.
Only 2 weeks possible.
2 weeks नहीं ले सकते.
1 week.
By way of last indulgence, we'll give you only 1 week. In spite of order dated 6/2/2026, the supplementary counter affidavit has not been filed. The learned counsel for the state prays for and is granted time till next Friday by way of last indulgence, failing which the case will be decided on the basis of materials available on the court. Next Friday.
Orders will be paid at and 4, CMP file number 9781 of 2024.
Since this was one item as for removing the infections, the
What is the defect?
defect regarding especially regarding the defect number 90, IGP that respondent number 2, 4, 2, 8 and 12 of the connected case have not been made party in the
Yes.
in the present case. What has happened in this case, my lord, sir, that they such a respondent has already been died, and for which I have filed one IA in the main writ application, and that was allowed by giving opportunity to furnish the notice within the prescribed time. But unfortunately, that has not been complied with. That's why my lord, sir, the
IA
case
number
we have.
4101 of 2026. The learned counsel for the petitioner submits that the interlocutory application has been filed for ignoring or
Yes.
removal with respect to defect number 90 within bracket Roman 2. And it is in relation to the fact that respondent number 2, 4, 8 and 12 of the connected writ petition, being the PC number 5258 of 2012, have not been made party. The learned counsel submits that since they died, therefore they are not being made party, and लीगल ईयर को क्यों नहीं पार्टी बनाए?
नहीं, लीगल ईयर्स के पार्टी बनने के लिए ही आईए फाइल हुआ है इन द रीट एप्लीकेशन, और उसी में ऑर्डर हुआ था नोटिस।
तो यहाँ तो आपको पार्टी बनाना पड़ेगा ना?
नहीं, तो अभी उसमें चूंकि एलॉ नहीं हुआ है, वो फाइनली एलॉ नहीं हुआ है, उसमें सिर्फ सिंपली ऑर्डर हम लगाए हुए हैं, दैट इज वो सीएमडी में ऑर्डर है, issue notice on IA number so and so.
And he submits that since they have not been substituted in the deputation so far, therefore they have not been made party in the present proceedings. Any objection? कहाँ पार्टी बनाए? नहीं बनाए ना, इसीलिए वही एक्सप्लेन कर, वही उसी को एक्सप्लेन करें कि डेड पर्सन को पार्टी नहीं बना सकते. The learned counsel for the respondents has no serious objection so far as the interlocutory application is concerned. Considering the appropriate submission, the defect as pointed out by the office with respect to defect number 90 within bracket Roman 2 is ignored for the present.
So far the CFP is concerned, that is certain.
Office is directed to place this case under appropriate heading on its plan.
Okay.
Item 5, CMP 5145 of 2025. Item
Defective.
yes, yes.
One. Nobody appears on behalf of the petitioner. Time till 14th of May is granted to the petitioner to remove the surviving defects to entry. If the defects are removed within time, post this case on 12th of June.
And reading for orders, item 6, second appeal 118 of 2010.
Was already 23/2026 was directed to file a supplementary appeal regarding the original copy of the receipt of this custody summons, which has been filed in the supplementary affidavit dated 9/4/2026.
So what is to be done now? Whom have you served through custody? किसको किसको सर्व करती है?
Responding to 13, yes.
और respondent number 2 and 15 का?
For any DT. And for 15 is legal his husband who died with us.
सप्लीमेंट्री एफिडेविट में कहाँ लिखे आप किसको सर्व किए हैं? इसके पहले तो लिखे होंगे ना, कस्टडी समन आप किसको सर्व किए हैं? Yes, tell me. By which order you were supposed to take steps through custody? Which is that order? Respondent number 13 and 15.
15 husband Ram 15 successor Ram husband was who died was on 17/12/2025. In idea number 17/20/26.
You see, there is an order dated 14/4/12/25 to issue notice to the proposed legal heirs and successor of deceased respondent number 13, Majhari Devi, and deceased respondent number 15, Gangia Devi. So you have served to both of them.
When the notice has been issued to the respondent number 15 Gangia Devi, in report it is found that his husband Ramnath Shah, who also died on 17.
Husband से क्या मतलब है? Gangia Devi has expired.
Expired.
Okay, her husband has also expired.
Also.
He was the legal heir.
Husband is the legal heir. Yes, who was.
So
And
there is nobody.
No.
Class 1, class 2 कोई नहीं है.
Class 1 son and daughters.
Yes.
Others class 2.
The learned counsel for the appellant has submitted that क्या वेरीफाई हम नहीं जानते, हमें आप लोगों को कुछ पता ही नहीं है. सेकंड अपील में सक्सेशन होता है, ऐसे थोड़ी होता है. The learned counsel for the appellant seeks adjournment. post on 12th June. देख लीजिए भाई, हस्बैंड का डेथ हो गया, ये सब तो आना चाहिए ना. लिखे हैं क्या हस्बैंड का डेथ हो गया?
ID number 17 of 2026 will come.
Husband is dead and there is no other legal heir. ऐसा लिखे हैं?
No other legal is currently on husband.
तो इससे क्या हो गया? हस्बैंड डेड होने के बाद प्रॉपर्टी सरकार को चली जाएगी.
Verify the class
होंगे बच्चे उनके, राइट? किस दिन है? 12 तारीख को, 12 जून, 12 जून खुलने के बाद, छुट्टी के बाद.
Item 7 CMP 387 of 2018.
It's the restoration. Earlier in the IA for substitution, notices were issued.
So what happened to the notice?
As per the office report, the notices have been served.
To 6A and 6B. They are the only persons to be
They are-
substituted. Yes. Which is that IA?
IA number 97 2026.
The learned counsel for the appellant, petitioner, refers to IA number 971 of 2026 and has submitted that notice was issued to the proposed legal heirs and successors of respond number 6, which as per office report has been served. He died on 26/1/2023. In spite of service of notice, nobody has entered appearance. The learned counsel for the state is present. After going through the IA number 971 of 2026, the prayer for substitution of respondent number 6 is hereby allowed. The learned counsel for the appellant. Petitioner is directed to delete the name of respondent number 6 and insert the name of legal heirs and successors whose details have been mentioned in paragraph 3 of the interlocutory application in writing during the procedure. Post this case under appropriate heading on this Friday.
Item 8 CO20 of 2021.
Should we have tried to see in FA 47 of 2020, which has been received for reports and CMP have been filed for restoration.
FA 47 of
2020. This is for default and CMP has been filed for restoration.
CMP number
554 of 24.
इसका स्टेटस बताइए.
पेंडिंग है और उसमें प्रिंटरी ऑर्डर हुआ
2024 पेंडिंग है मतलब कोई डेट हमारे पास लगा नहीं. मेरा ऑर्डर
उसमें डेट नहीं लगा हुआ है प्रिंटरी ऑर्डर का उसके बाद का स्टेटस
ये CMP मेरे से टाइड अप नहीं है. The learned counsel for the petitioner up with cross objector submits that this cross objection was filed in connection with first appeal number 47 of 2020, which itself has been dismissed for default, and CMP number 554 of 2024 is pending. She submits that in view of this, the matter will be adjourned. Post on. ये मेरे पास है तो फर्स्ट अपील है इसीलिए लगा हुआ मेरे पास. Post on 7th of August इसमें appear हो जाइएगा, आपका CMP हो जाएगा टेकअप लेके बस घूमते रहिए।
Item 9, CMP 109 of 2025.
This is defective.
Next, orders.
अर्ली हियरिंग के लिए आप अर्ली हियरिंग बोल रहे हैं तो क्या करना है बताइए। अच्छा नॉट प्रेस्ड, अब क्या करें? क्या चीज का रिस्टोरेशन? रिट पिटीशन। एनी ऑब्जेक्शन? Any objection? CMP number 109 of 2025. When it comes, this petition has been filed for restoration of the case number 2963 of 23, which is dismissed on account of non-removal of defects in terms of order dated 3/5/2024. The learned counsel for the petitioner has submitted that on account of inadvertence. Certain typed copies could not be filed, and the case has been dismissed for default. He submits that the writ petition be restored, in which the petitioner would suffer irreparable loss of immunity. The learned counsel for the state has no objection so far as bail or restoration is concerned. After hearing the counsel for the parties, the time granted by the order dated 3/5/2024 in the case number 2963 of 2023 for removal of defects is extended till 8th of May. Is extended till 8th of May. This CMP is accordingly disposed of. If the defects are removed within the extended time, the office is directed to place the petition before appropriate date as per procedure.
State BCC. State BCC.
BCC.
Item 10, CMP 608 of 2025.
Interlocutory application bearing IN number 1948 of 2026 has been filed pursuant to order dated
1948.
1548 pursuant to order dated 28/11/2025, whereby it was informed by the counsel of the opposite parties that the OP number 4, 5, 8, 12 and 19 have expired much prior to filing of this present CMP. So moving forward to the substitution, so far as the case of OP number 4 is concerned, OP number 4 named Bhimako Devi, wife of Munchal Anjiyara, has already died before filing of the CMP. However, her son, namely Abhinav Anjiyara, has already been made party as respondent number 18. Therefore, Your Lordship, there is no such requirement for substitution. Moving forward to OP number 5, namely Shanti Devi. Your Lordship, I humbly submit that she has not yet deceased, and this is the clear-cut instruction that I have received from the client. So, no reason for substitution is required.
That's all. Who else? 5 is
five
alive.
is alive, Your Lordship.
8, 12 and 19.
Yes, Your Lordship. Further, OP number 8, namely Srimati Bilsi.
Who has stated that she has expired? You have stated that she has expired. What about 8, 12 and 19?
8 is right.
So if the parties have died prior to filing of the CMP, so you will file substitution petition or you will file addition of party?
It was the case that few OP numbers which were told to us by them that they have died. We have filed, we have tried to substitute, but already those respondents were already made party.
Just a moment. IA number 1548 of 2006. The learned counsel for the applicant has referred to paragraph number. कहाँ लिखे हैं that this respondent number 5 is alive?
Para number 7
has referred to para number 7 to submit that it has been wrongly informed by the respondent that respondent number 5 that OP number 5 has expired. Issue notice to opposite party number 5 through the concerned police station, for which requisite be filed before this court. The officer in charge of the concerned police station is directed to file an affidavit regarding service of notice. The notice should be served in presence of witnesses, and a copy of the Aadhaar of opposite party number 5 be also obtained at the time of service of notice. In order to ensure that the affidavit regarding service of notice be filed by the concerned police station, the state of Jharkhand is directed to be made as opposite party number 20 in red ink by the petitioner, and the petitioner is directed to serve a copy of the entire records of this case in the office of learned advocate, along with a copy of this.
One more fact that they have given that respondent opposite party number 5 had died,
Not
and they have
died.
given he had died, but he has 3 sons and 1 daughter, and he has given only one name.
Has
He is
not died.
9 opposite party 9 has died.
भाई बाकी सबका
वो
details तो
बाकी
देंगे।
लोगों का डिटेल्स दिए ही नहीं
आप
पार्टी
इसका response file कर दीजिए ना।
Yes, I will file response to that because it is very
In the
and the person had died before.
meantime, the counsel for the opposite parties may also seek instructions and file a reply to the individual.
Yes.
Post one question.